Well, let's bring you some news just in. Then the sentencing of Alutha Pasile is currently underway in the East London High Court for the murder of Nosicelo Mtebeni. Let's take a listen in.
A male person aged 25 years. I will, for convenience, hereinafter refer to him as the accused. I also do not propose to read references to cases that I referred to in my brief judgment. Earlier this week, I convicted the accused person of murder as well as attempting to defeat or obstruct the course of justice. He was convicted following his pleas of guilty to both crimes. It is tried that an appropriate sentence should reflect the severity of the crime. Give full consideration to both mitigating and aggravating factors surrounding the offender. Put differently, what should be considered at sentencing stage is the crime, the offender, and the interest of the society. Both counsel have referred to cases where these principles were enunciated. It is also tried that in assessing a sentence, regard must be had to the main purposes thereof. Those being to act as a deterrent, being aimed at deterring both the individual offender and other would-be offenders or prospective offenders from committing similar acts in future. It's also aimed at rehabilitating the offender, something that we've heard about a great deal during these proceedings. It is also meant to serve as protection to the members of the society against those who do harm to the society. And finally, to serve as retribution. This talks to giving effect to the society's outrage and desire for appropriate punishment to be imposed. I have been urged not to shun my responsibility of imposing a sentence and only taking into account the feelings of the society. I take note of that warning, even though I am mindful of the fact that members of the society, including the family of the deceased person, are angry and have every right to be. It will be with these principles in mind that I will approach sentencing in this matter. The circumstances surrounding the commission of the offences in question emerge from accused statement in implication of his plea of guilty. as well as evidence led by the state in aggravation of sentence, which was meticulously collected by the relevant personnel, the investigating officer, the doctor who performed the post-mortem examination. And they are briefly as follows. The accused and the deceased person, Ms. Nosicelo Mtebeni, had a romantic relationship since about January 2019. Although this seems to be a different period as to what was communicated to Ms. Stemba, who prepared the pre-sentence report. Both were pursuing their studies in East London at two different tertiary institutions. At the time of the incident, they were sharing rented accommodation in the city. And during August of this year, 2021, Ms. Mtebeni visited her parental home in Matatiele. On her return, accused grew suspicious that she was cheating on him. This led to an argument on the 16th of August. On the following day, which happens to be the fateful day on which deceased lost her life, accused went through his cellular phone in search of evidence of her cheating. And confronted her about what he alleges he found on her phone records. Deceased tried to regain possession of her cellular phone or to take her phone from the accused. Accused took a knife and stabbed her. When the knife fell, he pushed the deceased hard against the wall, causing her to fall face down. This resulted in a traumatic brain injury that brought about a deceased's death. The evidence of Dr. Zondi, who conducted the post-mortem examination on the body of the deceased, testified that formidable force was used in pushing the deceased against the wall. Resulting in the manual disarticulation of the neck between C0 and C3 vertebrae. With stretching of the brain stem. And he concluded that the likelihood is that the death of the deceased occurred instantaneously. Having been incapacitated by hitting her head against the wall, the deceased probably died even before his body landed face down on the ground. We know from accused explanation that this happened during the morning of the 17th of August. What happened to deceased lifeless body from then on paints a very grim picture. Reminiscent only of a horror movie. And apparently what was uppermost in accused's mind was fear of detection, fear of being arrested and jailed for killing the deceased. This clearly emerges from his statement. That is his explanation of plea, where it is stated that I saw that she was not breathing and that she was dead. I panicked as I was afraid that I was going to be arrested and jailed for having killed the deceased. I then went onto the internet to research how to dispose of a body. I came across a video showing a body being dismembered, being placed in a suitcase and thrown away. I decided to do this. So on the following day, being the 18th, accused visited a hardware shop where he bought items that he was going to use in dismembering the body of the deceased. This was, however, after he had, on the 17th of August, that is the previous day, having texted a friend to ask whether he had a saw which he wanted to use to cut something. It transpires that he then proceeded to do so, in other words, to dismember the body of the deceased by cutting the body into 7 parts or pieces. The gruesomeness of his actions become even more apparent from Sergeant Njoli's evidence. Namely, that the parts were stuffed in a suitcase, which excluded the hands and the head of the deceased. These Sergeant Joy found inside, that is the head and the hands were found inside the accused's flat on the 19th of August. Inside a beach bag, on top of which the hacksaw used to dismember the body of the deceased was placed. This was on the 3rd day after the deceased had been, the accused had killed the deceased. The suitcase containing the rest of deceased body was found at the corner of Fleet and Fitzpatrick roads. Accused and the deceased lived together at a flat in Fleet Street. The accused did not testify in mitigation of sentence or in respect of sentence. but details pertaining to his personal circumstances, his background, and circumstances or other circumstances surrounding the commission of the offences emerged from Ms. Temba, a social worker in private practice, in an extensive report that she had prepared. The accused appears to have having a very close to normal upbringing. Having a close relationship with his mother, save that his relationship with his father was not a very healthy one. Yes, he believed that his father was emotionally and financially abusing his mother. It also transpires that he is an intelligent, educated young man who holds a diploma in mechanical engineering as well as one in public administration. He is a first offender, and as I indicated earlier on, he pleaded guilty to both counts. As to the type of person that the deceased Ms. Nosicelo Mtebeni was, both as an individual and the manner in which she was viewed by her family, emerged from the evidence of her distraught father. Who painted a picture of a driven and ambitious daughter, who was on the verge of completing her studies in law, who had intentions to further her studies and read towards a master's degree. Described as quiet or reserved, but loved by her whole family, including her stepmother, with whom they had conversations telephonically almost every day or after every one day. A well-rounded person who loved nature and had an interest in farming, and was assisting her father in this regard. We also got to learn of the devastating and trauma that has been brought about by the passing of Ms. Nosicelo Mtebeni, especially regarding her family. The trauma brought about by her father having to identify her daughter's body at the time when it was in pieces. Thankfully, the staff at the pathological laboratory managed to reconstruct the body, and at least at the time of interment, she was in one piece.
ethathana abasebenzayo ngokuchwephesha bawudibanisa umzimba wakhe ngexesha efihlwa umzimba usele udibene.
Both Ms. Kyanki for the accused and Ms. Turner for the state are in agreement that the only appropriate sentence in the circumstances of this case is that of a lengthy term of imprisonment or direct imprisonment.
Futhi sinegqwetha abaningelana yokuba esona sigwebo sakho sikufanele sisigwebo eside engaphakathi kulungu.
Where they diverge, however, is when it comes to the length of the sentence that they recommend accused should be sentenced to.
Apho kuhluka khona ngezimvo zokuba malibe lide kangakanani ithuba ethi azawuthi elithodoza.
Ms. Kyanki suggesting 20 years imprisonment.
Igwebo lesidani elecebisa ngemashumi amabini eminyaka ethodoza.
And in motivation of this submission, she submitted that the accused was remorseful.
Uthe nxa exhasa oko uthe umangalelwa iye wabonakalisa ukuzisola.
Having verbally indicated so,
Iye watsho oko ngomlomo.
through his pleading guilty to the charges,
Ngokwenza oko uye wathi-ke walivuma ityala okanye izihlolo zombini.
and also based on his personal circumstances, including the fact that he is a first offender.
Futhi-ke nokuba uyaqala ukuhamba nalo mthetho.
Ms. Turner, on the other hand, urged me to impose imprisonment for life,
Xalela labathuthisi licele into yoba makasuke entolongweni ubomi bakhe.
and bolstered this submission by highlighting aggravating circumstances which are present in this matter.
Loo nto ke wathi wacacisa izinto ezenza into yoba ityala eli libe uqilima ngakuye ke wacacisa kwingxelo yakhe.
In her evidence, Ms. Stemper also had expressed some doubt as to whether or not accused had expressed genuine contrition or remorse.
Mr. Mbanayo, nabo amathanda into yoba ingaba umangalelwa uyisola ngekwenzileyo kwisini na ngokuthembekileyo na.
Even Mr. Mtebeni was not persuaded that the accused was genuinely remorseful.
Naye usewebuze akagcwalanga ngoba ingaba nyani umangalelwa uyazisola.
Pointing out that the offences took place or were committed in August, it's only now that he is appearing in court that he expresses some remorse.
Isehlo senzeka ngo-August kungunazalekela ezocela uxolo ebonisa into yokuba uyazisola.
Whilst it was submitted on behalf of the accused that the murder was not as a result of direct intention on his part, that factor should be taken as a mitigating factor.
Into yokuba ebengezo njongo zokwenza esi sehlo loo nto mayithathe emkhethelelayo.
However, Ms. Turner drew my attention to authorities or an authority that indicated that that was by no means a mitigating factor.
Mr. Nage naye wacapula kwincwadi zomthetho apho kumsapho lokuba elo nqaku wayelonqaku elikhethelelayo.
Or was not necessarily a mitigating factor.
Ngoba ngelo nqaku alithetheleli.
I agree with both counsel that the only appropriate sentence will be that of a direct term of imprisonment.
Siyavumelana nedoda nomthuthisi lokuba isigwebo simfanele sisigwebo sakhe phakathi.
The matter of genuine contrition or remorse, as I've indicated, was dealt with at length by both parties.
Into yokuba uyazisola uzisola kangakanani elo nqaku lithe lathatha nabo bobabili igwebo.
Unfortunately, I have to align myself with the school of thought that is not persuaded that the accused has displayed a genuine remorse.
loo nto kufuneka nam ke ndizabelise into yoba ingaba yena ummangalelwa uye wabonakalisa ukuzisola ngokwenentsini.
From the circumstances that I have outlined surrounding the commission of the offense, the fact that all he says is that he panicked thinking that he was going to be arrested.
Ngoba okothe kufike kuthi engqondweni into yoba yena ngalo lonke lixesha ulicinga ngecinga into yoba uzawuba.
Nowhere does he say, I was distraught realizing that I had taken the life of my long-standing girlfriend with whom I had shared space for some time.
Akho ndawo ethi mna ndahlupheka okanye ndakhathazwa kwinto yoba ndithathe umphefumlo womntu ebesele ndiyandithena naye kwindlela yokuqala.
The remarks that were made in State versus Makiki that Ms. Turner referred to explain in clear terms what amounts to remorse, genuine remorse. And even from the evidence of Ms. Temper, accused does not seem to be genuinely remorseful of his actions. The statistics that were alluded to by Ms. Turner pertaining to gender-based violence are quite alarming. And one wonders what it will take for the message to sink that women and other vulnerable members of our society are entitled, deserve to have their rights respected and protected at all times. Many campaigns take place to raise awareness about this scourge. Even at this stage, we're in a period of activism, 16 days of activism against for violence against women and children. I have no doubt that the accused is aware of these campaigns and of this hue and cry about violence against gender-based violence. We heard that he researches everything. He's an intelligent, educated young man. As I say, one wonders what will it take for everybody to realize that women also have rights to equality, right to dignity, right to bodily integrity, and so on. The accused has shown that he has complete disregard for the rights of others, especially as we have seen rights of the accused person, of the deceased, I'm sorry. A far cry is pointed out by Ms. Turner from his professed love for the deceased person. Even in death, he had no respect for the deceased. Her dumping her body, which was cut into pieces in a street corner.
ukuthi ke amthathe ayomlahla endlini yokuba emncinci.
Going back to the question of remorse, it baffles me why this remorse did not kick in during the 3 days when he went through all the attempts to avoid detection for the killing of the deceased.
Okukusola kwakhe ndiye ndizibuze umbuzo othile. Kuqaleni emva kwentsuku ezintathu zonke ehleli eceba ukumnquma bekutheni akasoyi ngaloo mzuzu.
But as I indicated earlier on, as courts, we are not to shy away from our responsibility to assure members of the community, including women and children, that they too enjoy protection of the law. And in my view, this can also be achieved by the imposition of harsh sentences. Offenses that are commensurate to the seriousness of the offense. The accused may now stand up to receive his sentence. Having considered all these aspects that I have referred to, I am of the view that the following sentences will be appropriate in the circumstances. In respect of murder, the accused is sentenced to undergo 25 years imprisonment. In respect of attempt to defeat the ends of justice, the accused is sentenced to undergo 10 years imprisonment. The sentence in count 2 is to run concurrently with the sentence imposed in respect of count 1.
Sizawabisana nesigwebo osiphumelele ngehla esokubulala seminyakeni ngamashumi anesihlanu.
That the court will adjourn for the day.
All right, well, that's news just in then at the moment coming in from East London. Alutha Pasile sentenced then to 25 years in prison for the murder of Nosicelo Mtebeni, as well as 10 years for defeating the ends of justice, and those sentences to run concurrently. The judge also talking about appropriate sentencing to reflect severity of the crime, taking into account mitigating as well as aggravating circumstances. Also weighing in on the fact that nowhere does the accused say that he was distraught about murdering Nosicelo Mtebeni, that he showed no genuine remorse, and that even in death he showed no respect for the deceased. And of course that's indicated by how he discarded of the body after in fact dismembering the body of Nosicelo Mtebeni, also saying that in the 3 days that he was trying to conceal the body and get away with the murder, at no point did Alutha Pasile's remorse, in fact, kick in. So that's basically in the gist of what the judge had to say then in sentencing Alutha Pasile this afternoon.